Namaskar. Welcome to our new video. Today we are going to do a quick revision in a simple language through a shared PDF notes in Interpretation of Statutes. Total 56 topics have been covered in this video. You may download complete notes from the description link or from the first comment of this video. In this note, we tried to cover all the major topics which are important for the law students and competitive exams points of view. Let's start the topic which all are covered in the entire notes are as follows. Meaning of statutes, meaning of interpretation of statutes, definition of interpretation, objectives of interpretation, nature and scope of interpretation, classification of interpretation. Interpretation means व्याख्या करना. Functional interpretation, case law interpretation, interpretation versus construction, statutes classification, definitions of statutes types, general principles of interpretation, aids to interpretation, beneficial construction, strict construction of taxing statutes, strict construction of penal statutes, operation of statutes, presumption, doctrine of territorial nexus, doctrine of pith and substance, doctrine of colorable legislation, doctrine of repungency, doctrine of severability or separability, doctrine of eclipse, doctrine of prospective overruling, doctrine of occupied field, doctrine of parimetria, doctrine of implied power. Other one are doctrine of implied prohibition. Latin maxims are also mentioned in this topics. General Clauses Act 1897, Basic of Legislation, General Rules of Construction from section 5 to section 13, Effect of Repeal, section 6, and so on. There are lots of topics till 56. Approx 56 topics are covered in this notes. So let's start with description of topics. Meaning of statute. What is the meaning of statute? Statute is a written law enacted by the legislative body of the government. Example: IPC, CPC, CRPC, Indian Penal Code, Civil Procedure Code, Criminal Procedure Code, Indian Evidence Act. Now it's BNS, BNSS, BSA, etc. Meaning of interpretation of statutes. The term interpretation has been derived from the Latin term interpreter. Interpreter means दुभाषीय. Like आपकी भाषा, आप अगर हिंदी बोल रहे हैं तो आपकी भाषा समझ के अगले बंदा जिसको हिंदी नहीं आती उसको समझाना उसके लैंग्वेज में. अगर वो इंग्लिश बोल रहा है तो इंग्लिश में, जर्मन, फ्रेंच, इटालियन, रशियन जो भी लैंग्वेज बोल रहा है उसमें समझाना. So the term interpretation has been derived from the Latin term interpreter, which means to explain, expound, understand, or translate. Interpretation of statutes is the correct understanding of the law. As per Salmond, interpretation is the process by which the court seeks to ascertain the meaning of the legislature through the medium of the authoritative form in which it is expressed. And their objectives are legislative language. It may be complicated for a layman and hence requires interpretation. It is also necessary to ascertain the meaning of ambiguous and contradictory words. Legislative intent, to know the intention of the legislature. The intention of the legislature assimilates two aspects: the concept of meaning, that is what the word means, the concept of purpose and object. The meaning and application of certain words can change over time as society changes, which necessitates judges to clarify the meaning of those words and provide their current meaning while keeping in mind the intention of the legislature. मैंने ऑलरेडी इस नोट्स को बहुत ब्रीफ में बनाया है जो कि सेल्फ एक्सप्लेनेटरी है. दिस इज द ओनली रीजन आई एम नॉट गोइंग टू डिस्क्राइब ऑल द थिंग्स. जहां भी कोई लैंग्वेज टफ होगी या कोई वर्ड्स वैसे टफ होंगे तो मैं डेफिनेटली उसको डिस्क्राइब कर दूंगा. अदरवाइज फिर उसका डिस्क्रिप्शन देने का कोई मतलब नहीं बनता है. बिकॉज ये ऑलरेडी कंसाइज मैनर में है। फिर भी एक मैं मोटा मोटा अगर लेके चलूं तो जैसे फॉर एग्जांपल ऑब्जेक्टिव्स है, ऑब्जेक्टिव्स के दो ऑब्जेक्टिव्स हैं इसके। लेजिस्लेटिव लैंग्वेज, इसमें जो लैंग्वेज यूज किया गया है वो लैंग्वेज लेमैन लैंग्वेज को टफ ना लगे, लेमैन पर्सन को टफ ना लगे, इसलिए उसको इंटरप्रिटेट किया जाता है, उसको डिफाइन किया जाता है जिससे कि फिर वो इजिली अपना मैसेज कन्वे कर सके। इसका इंटेंट जो है उसका इंटेंट यही है कि जो मीनिंग है, जो वर्ड्स है, वो क्लियरली डिफाइन हो आगे, और जो पर्पस और उसका ऑब्जेक्ट है जिस वजह से वो मेंशन किया गया है वो क्लियरली आगे एक्सप्रेस हो सके। इसके नेचर और स्कोप, नेचर ये है कि द नेसेसिटी फॉर इंटरप्रिटेशन अराइजेज, ये नेचर का मतलब ये हुआ कि ये इसकी जरूरत कब पड़ी, जब कुछ वर्ड्स क्लियर नहीं समझ में आ रहे थे। एम्बिग्यूअस से मतलब कि वो क्लियरली अपने मीनिंग नहीं डिफाइन कर पा रहे थे, एक वर्ड के मल्टीपल व्यूज पॉसिबल थे, जहां पे कोई प्रोविजन मेंशन किया गया है उसका डिफरेंट मीनिंग निकल रहा था, इसलिए इंटरप्रिटेशन की रिक्वायरमेंट थी। इंटरप्रिटेशन की क्लासिफिकेशन है जैसे लीगल, जो कि एक्चुअल रूल ऑफ लॉ होता है, ऑथेंटिक, जो लेजिस्लेचर से डिफाइन हुआ है, यूजुअल, जो हम लोग कस्टम और केस लॉ में यूज करते हैं, कस्टम इन द सेंस डेली जो रिवाज बना हुआ है बेसिकली, डॉक्ट्रिनल, डिस्कवर रियल एंड ट्रू मीनिंग, जो सिद्धांत होते हैं, ग्रामेटिकल और लिटरल, ग्रामेटिकली और लिटरल के हिसाब से क्या सही है, लॉजिकल और फंक्शनल। फंक्शनल इंटरप्रिटेशन क्या होता है, तो उसमें लिटरल इंटरप्रिटेशन और ग्रामेटिकल इंटरप्रिटेशन। It is the general rule of interpretation. Judges are not liberty to add, modify, or take from the letters of the law. They are required not to look beyond the language of the law, should strictly follow the language and directly translate its meaning. Logical interpretation या functional interpretation का मतलब है judges deviate from the literal meaning. They make look elsewhere to decipher the intent behind the law. This is done when the following conditions are met: an ambiguity, inconsistency, incompleteness, या in case of a logical defect in the spirit of the law. इसके लिए एक फेमस केस लॉ है RS कायक वर्सेस AR अंताल्या, AIR 1984, Supreme Court 684. The court held that if the words of the statute are clear and unambiguous, then there is no need for interpretation, and the court should use the natural meaning of the words used in the provision. Now, interpretation. It is a process of ascertaining the true meaning of the words, to determine the linguistic meaning of a legal effect, to adopt the simple meaning. Construction. Interpretation is the one thing and construction is the one thing. We are looking after the interpretation versus construction. Construction, it is the process of drawing conclusion from legal text, to determine the legal impact of legislative text. When the literal meaning of the text creates ambiguity, then construction is adopted. Statutes classification on the basis of duration, nature of operation, and objectives. So duration, it would be permanent or temporary. Nature, prospective, retrospective, directory, and mandatory. Objectives, enabling, disabling, permissive, prohibitory, codifying, consolidating, curative, repealing, and amending. Definitions are as follows. Prospective, regulates the future. Retrospective, takes away any vested rights. Directory, affirmative in terms. Mandatory, things to be done in a certain manner. Enabling, makes something lawful that would not otherwise be lawful. Example, public nuisance. Disabling, restricts existing rights. Permissive, to be done without commanding. Prohibitory, forbids doing certain things. Codifying, example, Hindu Succession Act 1956 are codified law. Consolidating, collates all statutory enactments on a specific subject. Curative, cures defects in previous law. Repealing, revokes or terminates another statute. Amending, amends on the original law. General principle of interpretation. Primary rules. The literal or grammatical interpretation. The mischief rule of interpretation, the golden rule of interpretation, rule of reasonable construction, rule of harmonious construction, and justa de maniera generis. Secondary rules are expresso unius est exclusio alteris. The expression of one thing excludes others. For example, rights mentioned in Article 15 and 16, etc. indicate that these rights are granted to Indian citizens, meaning they do not apply to foreigners. Contemporanea expositio est optima. Current interpretations are superior. Nocitio associs. The meaning of a word can be determined by the words immediately surrounding it. These are the legal maxims. Maybe the pronunciations of legal maxims which I am doing is not correct. So I would request to please refer the actual pronunciation what exactly it is. It would be beneficial for you in the future as well. Aids to interpretation. Meaning, an aid is a medium that helps or assists judge in interpreting statutes. Types of aids: internal aids available in the statute itself. Example: title, preamble, heading, marginal note. Definitional section, sections, subsections, punctuations, illustrations, exceptions, provisos, explanations, saving clause, schedules, etc. Title of the statute. Long title. Every statute is headed by a long title that describes the object of the act. Case. Then the long title of the act is relied upon as a guide to decide the scope of the act. Short title. Merely a name given for identification of the act and generally ends with the year of passing. Example: the Indian Contracts Act 1872. It has no role in interpreting a provision of the act. Preamble. It contains the aim and objective to be achieved. Case are Maharashtra Land Development versus State of Maharashtra. In this case, it has been defined. It was held that the preamble of the act is guiding light to its interpretation. Limitation of preamble. The court cannot use the preamble when the language of the statute is clear and unambiguous. The preamble cannot restrict or extend the meaning and scope of the words used in the enacting part. In case of conflict between the preamble and a section, the section shall prevail. Heading and titles of a chapter. Heading provides keys to interpretation and may be treated as preambles to the provisions that follows them. Case is Shelley versus London County Council 1949. A heading to one set of sections cannot serve as an aid to interpret another set of sections. This has been held in this case. Marginal notes, definitional sections, illustrations, provisos, not provisos, that is provisos, explanations, schedules, punctuations. Now external aids. External aids are dictionaries, judicial decisions, reference to other statutes, parliamentary history, historical facts and circumstances, other materials like eminent textbooks, articles and papers published in journals. Beneficial construction. When there are two or more possible ways of interpreting a section or a word, the meaning that provides more relief and protects the benefits intended by the legislation should be chosen. For example, if there are two interpretations, A and B is more beneficial, then the legislature will choose B by following this beneficial construction. Case law is Sheila Bias versus Union of India, AIR 1986. A social activist forwarded to the Supreme Court a copy of her write-up titled "Jailing the Mentally Ill." The court considered this as a PIL and directed rules in favor of child offenders. Strict construction of taxing statutes. Statutes dealing with tax are termed as taxing statutes. They are also known as fiscal status. Example: Income Tax Act, Gift Tax Act, Wealth Tax Act. To collect revenue from people to run the government is the objective of this. Collected money is utilized for the welfare activities of the people. This is the second objective. The famous case Hans Raj Sons versus State of Jammu and Kashmir. It was held that taxing statutes should be interpreted strictly. The meaning of strict construction of taxing statutes has been explained by Lord carens. According to him, if a person falls under the tax law, then tax should be imposed on him in all circumstances. Stages: first, the subject on which tax is levied or imposed. Second, the assessment of the liability of the assessee. And lastly, the recovery once the assessment is made. Fundamental principles of strict construction of taxation statutes. Any person liable to pay tax in accordance with the charging section must pay the tax, irrespective of hardships or inconvenience. मतलब किसी भी हालत में टैक्स पे करना है, चाहे वो कितने भी मजबूर क्यों ना हो या असुविधा हो रही हो उसे. A person not so liable cannot be brought within the scope of the law by giving a wider interpretation to the language. Taxing statutes cannot be interpreted based on any presumption or assumption. A fair and reasonable constructions should be given to their language without leaning to one side or the other. Ambiguous words should be construed in favor of the taxpayer. Famous case is Union of India versus Okra Nanwar. It was held at where two views are possible, the one in favor of the SSC must be passed. It seems something missed over there. So kindly check that. Penal statute strict construction. Statutes dealing with wrongful acts against the public are called penal statutes. Whatever is missing in the previous slide, it would be in the notes, so you may refer that. So no problem in that. Object. It's object to punish the offender by way of imprisonment, fine, forfeiture, etc. Forfeiture means संपत्ति को अधिग्रहित करना, कब्जा कर लेना, सरकार जो कब्जा कर लेती है, forfeiture. Principles of strict constructions of penal statutes. A person cannot be penalized without a clear letter of law. Presumptions or assumptions has no roles in the interpretation of penal statutes. The court cannot strain the words clear interpretation. Construction favorable to the accused must be referred. The purpose of the statute must be kept in view. A common sense approach may be taken if necessary. Application of language to developments in science and technology is permitted. State of Kerala versus Metalburgis. In this case, it was held that the expression any currency note or bank notes used under section 489A of the Penal Code, which has been changed now, it comes under the BNS, that includes currency notes of all countries and not only India currency notes. Operation of statutes, meaning when the statute has been implemented or since when it would be implemented or how the statute is working is known as the operation of the statutes. Their types are prospective nature of law, retrospective nature of law. Presumption. Things which we presume to be corrected and true are called presumption. Types like validity of the statute. For testing the validity, two things must be considered. The legislature that passed this statute is competent to do so, and the statute is not against the provisions of the Constitution and is not against any fundamental rights. Statutes are consistent with international law. The legislature does not commit mistake. The legislature used words that bear ordinary meaning. The legislature has knowledge of English grammar. The legislature has knowledge of law and judicial decisions. Our vested rights are preserved. The legislator does not intend any alteration in existing law except what is expressly declared. Presumption against retrospectively consideration of consequences. Doctrine of territorial nexus. This is an important maxim which also can come in the AIB. Usually comes in the AIB exams if you are going to review the past 10-year AIB paper. So it means territorial means territory and nexus means connection. According to this theory, laws made by the legislature are not applicable outside the territory, but if there is a sufficient connection between the state and the object, then the law can apply. Case law is Wallace versus Commissioner of Income Tax. In this case, a company from England was in partnership with an Indian company. Therefore, under this doctrine, the income tax department imposed tax on the full income of the company. Doctrine of pith and substance. Pith means true nature and substance means the most important part of something. According to this theory, when a question arises to determine which subject a particular law is related to, union list or a state list, there are always two lists. You must aware that. One is union list, other one is a state list. Then the court will closely observe the substance of the matter. Case law is Paula Kumar versus Bank of Commerce. In this case, the state legislature dealing with any matter may incidentally affect any item in the union list. The court held that whatever may be the incidental effects of a statute enacted by a state legislature, such matters must be assigned to the appropriate list according to their true nature and character. Doctrine of colorable legislation. According to this doctrine, one cannot do something indirectly if one cannot do it directly. In other words, if the constitution does not permit a certain provision of legislation, any provisions that has the same effect but it in a roundabout manner is also unconstitutional. This doctrine is based on the wider doctrine of fraud on the constitution, which means a thing is collateral when it seems to be one thing in appearance but another underneath. Case law is KCG Narayan Dev versus State of Odisha, 1953. Doctrine of repugnancy. Repugnancy means inconsistency. You may read it out. Doctrine of severability or doctrine of repairability. If a provision is inconsistent with the fundamental rights, the whole statute will not be held void. Only those inconsistent provisions become void. Example, the 42nd Constitutional Amendment Act 1976 declared only section 425 as void. It's not 4255, it's 425. Doctrine of eclipse. If any law made by the legislature is inconsistent with part 3 of the constitution, then the law is invalid and inoperative. Doctrine of prospective overruling. Prospective overruling means now onwards, which indicates that from the time of a particular decision, the law laid down in such a case will apply. Although the decision is overruling earlier law or rule, it will not have any effect upon earlier decided cases. Therefore, prospective overruling applies only concerning future judgments. Doctrine of occupied field. When the central legislature makes a law on a particular subject and thereby occupies the field, the state legislatures have no power to enact any law on that field. In the event of their doing so, the state legislation would to that extent become unconstitutional. Doctrine of pari materia. When two provisions of two different statutes deal with the same subject matter and form part of the same subject matter. Doctrine of implied power. The doctrine is also known as the doctrine of implication. Implied means not expressly provided in the constitution to perform the authority. Doctrine of implied prohibition. Expressed means mention of one thing implies the exclusion of another based on the maxim expressio unius est exclusio alteris. We already read this maxim before. General Clause Act 1897. Sections: preliminary, general definitions, general rules of construction, power functions, provisions as to orders, rules, etc. Miscellaneous 25 to 30. You may check it out. Objects are mentioned here. Applications are also mentioned here. Definitions of various terms. This act defines the following terms: Act, Affidavit, British India, Central Act, Central Government, Chapter, Collector. Basics of legislation. Preamble. Express the scope, object and purpose of the act. An act is a bill passed by both houses of parliament and assented to by the president. Definitions. Every act has definitions usually mentioned in section 2 of the act. Means or include, shall and may. General rules of constructions are mentioned here, which is from section 5 to section 13. These are the sections, and power and functionaries are mentioned under section 14 to 19. Substitution of functionaries are section 17. Successor section 18. Official, chief and subordinate section 19. Construction of orders etc. section 20. Read and do singular singles. It is a Latin term that means referring each phrase or expression to its corresponding object. Rule of construction ex vicarious acts, meaning a statute should be read as a whole. Construction in bohem partem. This maxim means that words used in a statute are to be taken in their lawful sense. Expression unius est exclusio alteris. When one or more things of a class are expressly mentioned, other of the same class are excluded. Falsis in uno, falsis in omnibus. False in one thing, false in all. Social legislation means laws designed to improve and protect the economic and social conditions of those groups in society that, due to age, race, sex, physical or mental disability, or lack of economic power, cannot achieve healthful standards of living. Law and social change. Social change means large number of peoples engaging in group activities and relationships that differ from those in which they or their parents engaged previously, meaning the change in the existing pattern of social life is known as social change. Elements of social change are mentioned here. Laws as means of social control are mentioned here. Identical expression. If contexts are not different, words, phrases or sentence should have the same meaning each time they are used in the statute. Gender rule 1 are mentioned here. Their exceptions. That is not gender rule 1, that is general rule 1, and the second one is a general rule 2. Apologies for my mistake, please correct it. Prospective operations of a statute. Their meaning: retrospective operations of a statute. This neither ignores the past nor selects the past but recognizes the past. Judicial activism means judicial dynamism. Judicial activism is a philosophy of judicial decision making whereby judges incorporate their personal views about public policy among other factors to guide their decisions. Judicial activism in India implies the authority of the Supreme Court and the High Courts, but not the subordinate courts, to declare regulations unconstitutional and void if they breach are incompatible with one or more clauses of the Constitution. Delegated legislation. When law is made by any authority other than the supreme authority, which is the legislature, it is also called subordinate legislation. Salmon said that subordinate legislation or supreme legislation. Legislative authority that delegates the power to make law to the executive authority is called delegated legislation. मतलब delegated मतलब किसी को assign कर दिया, किसी को अपनी रिस्पॉन्सिबिलिटी दी है कि मेरे बिहाफ पे आप करेंगे. इसके एडवांटेजेस हैं, डिसएडवांटेजेस हैं. क्लासिफिकेशन है, लाइक टाइटल बेस्ड क्लासिफिकेशन, नेचर बेस्ड क्लासिफिकेशन. Interpretation of the Constitution. In the interpretation of the Constitution, the judicial approach should be dynamic rather than static, pragmatic rather than pedantic, and elastic rather than rigid. Following are the key principles of that interpretation of the Constitution. Now it's end. If you found this video helpful, hit that like button, subscribe for more legal insights, and drop a comment with your thoughts or questions. Thanks for watching and see you in the next video. And apologies if any certain instances I am not able to meet. So thanks a lot. Thank you.